we are here on Mayor versus Regina Healthcare. Oh, I'm sorry, last case. In this case, we are here on Mayor versus Regina Healthcare for our last case of the day. And each party will have 15 minutes to present their argument. In your case, there's no one to rebut, so you just have your full 15 minutes. We won't have rebuttal time for you. The arguments are being recorded. When you start, please make sure you introduce yourself for the record. Please keep your voice up and remain behind the podium when you speak so you're able to be recorded well. I don't know if it's relevant in this case. You should not use names of children, minors, and victims during this case. I know there are some issues regarding healthcare issues. I don't know that we specifically know anyone by individuals, but you can refer to them by some type of general reference, like the residents or something like that, rather than names. The judges have read your brief and are ready to proceed whenever you are.
Thank you, Your Honor. May it please the court, fellow counsel. My name is Jonathan Good on behalf of Appellant Regina Health Center, and this is Attorney Tina Rhodes with Weston Hurd, also with Weston Hurd. Thank you for your time today. Again, may it please the court. And we will proceed, noting that there is no brief, that there is no opposing counsel here. I think that says it sends a message that these issues are not that important to the appellee. They are not material to the appellee. So what brings us here today, and we are going to ask that this court reverse the trial court's order which wrongfully compelled disclosure of identity of contact information that would directly relate to diagnoses of that person. That's the most important, deepest connection here that I want to emphasize. This is not a simple disclosure of names and addresses. This goes a deeper level because the disclosure of identity, names, contact information of this non-party patient that the appellee plaintiff knows has diagnoses from his treatment and care at Regina Health Center. By ordering disclosure of the identity, it completes the link that, by the natural unfolding of events, will disclose into the public record the diagnoses, medical care, and medical treatment of that ordered individual. The plaintiff, appellee, worked as an STNA for a medical care provider, Regina Health Center. They are the providers, health care providers of personal medical care. They have doctors on staff, they have nurses on staff that provide the personal medical care, they make diagnoses, they provide treatment. Our brief says you cannot disclose communications, information of a non-party individual who is receiving treatment, care from doctors. It's private health care information. It's an invasion of the patient's privacy. It's a violation of the patient's Bill of Rights, the nursing home Bill of Rights, or the patient.
Let me start asking this. We're referring here right now. You seem to be referring to the one interrogatory that which know the identity of the person in paragraphs 43 through 46 or 7 of the complaint. That was one request. The other request was for witnesses, to paraphrase, witnesses to the events that alleged regarding. So are you objecting to your client providing the names and identification information for the witnesses to this event? Not the individual who was mentioned in paragraph 43 to 47, one interrogatory. The separate interrogatory that I recall being, I want to know the witnesses to these events.
If they were patients at the nursing home receiving medical care and treatment
You
Yes,
object to
I
their,
object. If they are witnesses, visitors, you know, third-party vendors who come in, that may see something, not get, and who are not receiving medical care, treatment, I don't see an objection there. I don't see a HIPAA violation. I don't see doctor, patient, physician. I don't see the communication of diagnoses. So it would have to be, we would not have an objection so long as it was narrowly tailored to people not receiving medical care, third-party vendors that have no knowledge of medical information care provided. But we do object to the names of people seeking care from the healthcare provider. That's private information in the Nora Park. The nursing home couldn't even disclose the names of their patients' residents on a directory.
and is that pursuant to both the nursing home privacy statute and the patient-physician statute?
Yes. So, at first glance, I think the trial court did its split the baby and didn't really connect that whole natural consequences of disclosing the identity of a non-party patient. And they just split the baby and they saw the Mays case, which was a witness. They weren't seeking, they didn't connect the witness to a diagnosis, to medical treatment, to care.
The witness in that case, as I recall in May, was a resident of a nursing home or an individual in a hospital that was a patient. They weren't the witnesses we're talking about that might have been a vendor or a third party that just happened to be there, if I recall May correctly.
Yes, but what taints this case and what Appellees did to taint and just ruin their interrogatory request and request for production was that they unilaterally disclosed this individual's diagnosis, diminished mental capacity, incontinence, they call it toileting issues. This is a non-party.
Well, we
And
still
his
have a
family-
distinction, we would still have a distinction to decide between this resident who had some of her medical condition described in the plaintiff in one interrogatory, and this other group of people that are, I want to know the witnesses to this incident, some of which may be nursing home residents. And you would say under, at least under May, if we were to follow May, we would say, May would say those witnesses may come in, you would, of course, take issue with May anyway, as I recall.
Yeah, and May is old, outdated law. It's from 2009.
Has the statute changed since May, do you know?
This, I don't know.
But the
Nursing
general rationale
bill
of May
rights.
seemed to me to be that just the ID and contact information, that sort of stuff, wasn't something that was considered by the statute that's not used to provide treatment information to the doctor. They can treat me without knowing my name or information, so that's not giving any confidential information to a person by giving that information. And how is providing in this case just that identification information in a way giving anything that's needed for treatment by the physicians under the physician statute, not the nursing home statute?
But they've already disclosed it. That's my point.
Yeah, I don't disagree with this particular case. These things are in the complaint, and that's been alleged. They're not asking for any further information or verification of that. We're just saying, they're just, as I understand their interrogatory, we just want to know the name of this person.
But subsequent to May, that type of information will link the name and the individual to their medical care and treatment. And that is prohibited by law, and that
Either
has.
party seek a protective order?
Pardon?
Did either party seek a protective order in this case below on what was going to be disclosed as far as the arguments about compelling?
I believe Regina Health Center did in their motion for a protective order, yes, that brought this issue directly to the court's attention.
And did they ask a protective order of, if this is produced to them, we want an additional protective order indicating that only the attorneys can view this in this particular case?
There is, I don't know, they did not ask for an in-camera because there's a case that says even with an in-camera review, it's still not permitted to be disclosed. So, that's why they took such a hard stance, and it's a hard stance, it's not even a hard stance, it's what 3 different statutes state. So, and Regina Health Center has a duty to not disclose this. They are required not to disclose this, so they have to comply with these statutes. In Menor Park, they come out and state law does not permit the release of this information. And then the May case is based on an Illinois state court case. And that Illinois state court case was later, another appellate district in Illinois totally, reversed or, took the exact opposite stand and said, even the identity and contact information of the patient is not permissible. They did that a couple of years later. That's why we say May is really not applicable and doesn't take into this specific situation. But the subsequent case laws of Roe, Menor Park, and Biddle kind of fill all this in. And again, I want to emphasize what's so different here, besides that distinguishes this from May, is 2 things. Plaintiffs are trying to backdoor get around the statutes because they already have the confidential treatment records that they're not allowed to disclose by statute. They got that information because the employee was an STNA providing care, so he knows the diagnoses, and they're backdooring to get identity information that is prohibited to be disclosed by statute. So we're asking you, don't let them backdoor this. Secondly, what? They don't need this information. This is an employment case where they allege discriminatory conduct. The non-party has no information. They are not an element of proof. In a discrimination case, you look for direct comparators, fellow employees who were treated differently.
Well, did Regina not raise that there was a non-discriminatory reason for the ending of this plaintiff's employment? And the burden shifted back again to the plaintiff to prove that this wasn't a non-discriminatory reason?
This is an even more distinguishing factor. Plaintiff FLE was not terminated. He voluntarily resigned.
Well, that's an issue, right? I mean, unless, of course, it's not been raised, but this is a discovery issue. We're not.
But it's a discovery of material information. And the material information in a discrimination case has nothing to do with non-parties' medical conditions. It has everything to do with how other STNA individuals were treated.
Did you object below on the materiality, or is your objection based upon merely the statute?
Both. They did raise, they thoroughly raised it, and it's, they cite discovery is only permitted for material.
Did the trial court rule on that issue of materiality or merely on the question of the statutes?
They just ruled on the question of statutes. So, and there was very little explanation of what, why or what. So the only explanation was they didn't go that deeper route of what they were actually ordering to be done and the downstream consequences and disclosure and violation of law. This is a much, much deeper situation than just ordering names and addresses of non-parties who were not receiving any treatment that may have witnessed something.
Well, I know you're out of time,
Oh.
and again, just, you want a little bit from the podium, so please stay at the podium.
Okay. So, I didn't mean to talk so long as the last one, but, so we respectfully request that the court reverse the trial court's order and instruct the court to decline compelling disclosure of the identity and contact information sought in interrogatory number 21 and any patients who receive treatment care, personal nursing care diagnoses.
You have no need to apologize for taking all your time, that's what you have. We do thank you for your presentation. The court will take the matter under advisement and issue a decision in due course. The clerk of court will mail a copy of your decision to you on the date of release. The opinions are also released on the Ohio Supreme Court website. This being our last case, the court is now adjourned until